Okay, so welcome to what I certainly intend to be the final lecture in my series of lectures on Hobbes. As you know, I'm a little bit behind where I wanted to be, and so it may be that there'll have to be some holdover that will eat into our time on Locke next week, but it's certainly my intention to try to get through everything. I'm going to give it a college try and see how we do. This is where we got to at the end of the last lecture. You'll remember that I was drawing attention to the way in which Hobbes's sovereign has an unlimited, despotic, absolutist character. And this, of course, is something that has repelled many of his readers. And later on in this lecture, I'll talk a little bit about individual liberty, which lots of commentators have unsurprisingly thought is imperiled by this despotic figure of Hobbes's Leviathan. So the absolute character of Hobbes's state has given rise to a great deal of concern. But I was explaining that there are at least some important qualifications that need to be added to this. And I had mentioned one of these qualifications, which has to do with Hobbes's admission that there are a couple of, albeit very, very narrow and minimal, exceptions to his expectation that citizens unconditionally obey the sovereign. And I discussed a couple of cases involving self-defense at the end of the last lecture. So that's where we got to. But there's another important qualification that needs to be added to our view about the unlimited character of Hobbes's sovereign power. Because it's important to recognize that while Hobbes insists that sovereignty is unlimited, that isn't necessarily the same thing as saying that government is always unlimited. Because, as I said very early on in this series of lectures, there is a distinction to be drawn between the state, which is the locus of sovereignty, certainly for Hobbes and for many others today, and the government, which is the framework of institutions, the apparatus of administrative bodies that actually runs the country day to day. Now, people often carelessly use state and government as synonyms, as if they're interchangeable, but they're not, and Hobbes clearly recognizes this. So he distinguishes between the sovereign itself, which is the locus of state authority, and what he calls ministers of the sovereign. And when he refers to ministers of the sovereign, that's his own distinctive language for what we would today call the government, legislatures, courts, administrative agencies, the CIA, the FDA, the police, the army, tribunals established by state and local governments, right? All of those administrative, legislative, executive, and judicial bodies, because the courts too, and judges are simply ministers of the sovereign on Hobbes's view, those comprise what we would call the government. But they're distinct from the sovereign and the state that is in the background and that authorizes these bodies and determines the rules under which specific individuals are qualified to serve, for example, as a judge or as a member of the House of Representatives or as the president, indeed, right? So it's important to see that if Hobbes were looking at the United States today, he would not suggest that Donald Trump or Nancy Pelosi or Mitch McConnell or any of the 9 justices on the Supreme Court, he would not say that any of them are sovereign. He would simply say they are ministers of the US sovereign and they serve in the government that the sovereign has established. I mentioned in the last lecture, I quoted from a Chinese judge refusing what he regarded as the Western assumption that the judiciary should be independent. And as I said in the last lecture, Zhu Shang's suggestion that the judiciary is not independent of the state, at one level, Hobbes completely agrees, right? Hobbes would, of course, say that the judiciary, like every other ministry of government, is simply a creature of the sovereign will. It's something that the sovereign establishes, and it's something that the sovereign promulgates rules that determine who gets to serve in these various official capacities, right? So in that sense, Hobbes and Shang are at one in saying that the idea of an independent judiciary is kind of senseless. But if you think of the judiciary, as Hobbes also does, as one branch of government, one particular ministry of the sovereign, that, as in the United States, may have the power to oversee and in some cases invalidate actions taken by other branches of government, like, for example, Congress, as in the case of judicial review in the United States, then it can make sense on a Hobbesian view that the judiciary can be thought of as independent of some branches of government. And, of course, the doctrine of the separation of powers in the United States is in part the doctrine that the powers of the legislature are distinct from and independent of the judicial branch. And as long as you don't think of that as a division of sovereignty, but merely a setup in which different branches of government are established in a way that allows them to check each other, then I think Hobbes has no difficulty allowing that branches of the government are sometimes independent of each other, and therefore that you can have, in that sense, an independent judiciary, a judiciary that is at least independent of the executive and at least independent of the legislature. So there is a residual sense in which even Hobbes can allow that the judiciary ought to be, in a certain sense, independent. But of course he doesn't think that the judiciary can ever be, nor can any branch of government be fully independent of the sovereign, because they're simply the sovereign's creatures. You might say, well, look, if Donald Trump and Nancy Pelosi and the 9 justices on the Supreme Court, if they're not the US sovereign, who is the sovereign in the United States on a Hobbesian analysis? One answer you might be tempted to give is that the Constitution is the sovereign. But of course, Hobbes would say it can't be the Constitution, because the Constitution is just a document. The Constitution is just a piece of paper. And a piece of paper doesn't have a will. A piece of paper doesn't choose anything. A document doesn't have its own preferences, its own goals, in the way that a state and a sovereign has its own will and aims and interests and so forth, right? So the Constitution can't be sovereign. What then is the sovereign in the United States? And I think Hobbes's answer has to be that in the United States you have a special kind of democratic sovereign that consists of a body of citizens that can from time to time, and indeed at the founding, assemble and ratify or amend the constitutional document itself. Understood that way, the Constitution is simply the articulation of the US sovereign's will, and that will comes from a body of citizens, that ratifies and amends the Constitution, right? So you have a kind of democratic sovereign in the United States, and it consists in this body of people who from time to time step forward in public life and amend the Constitution when it sees fit, right? Now, of course, understood in that way, the US sovereign has the following odd feature. It has the feature that most of the time, the US sovereign is more or less dormant, right? It doesn't get involved in day-to-day government. It establishes a constitution. It lets the machinery of government whir away according to its own rules, and it rarely intervenes to modify the constitutional setup. From time to time, in historical, at particularly crucial historical episodes, this assembly of citizens will come together again, and alter the Constitution when it deems necessary, as, for example, at the end of the Civil War, a big ruction, a bloody interruption in the life of the political community of the United States, and amend the Constitution and formally forbid slavery, for example. But in between these moments of great constitutional moment, when the US sovereign, as it were, rouses itself, comes together and takes action and actively alters the constitutional settlement, the sovereign is detached and in the background and doesn't get involved. And Hobbes uses an interesting metaphor. I mean, he recognizes the possibility that a sovereign could be like that, and he uses an interesting metaphor to describe such a sovereign. He refers to it as a sleeping sovereign. And that, as many analysts of the United States who are tempted by a Hobbesian framework, that is the correct way to think of the sovereign in the United States. You have a democratic sovereign, this body at whose pleasure the Constitution exists, is established, and is subsequently amended, that is asleep most of the time, but at crucial historical moments it rouses itself and changes the Constitution when necessary, right? Once you understand the US Constitution that way, of course it becomes relatively easy to say that under the constitutional settlement that this body has accepted, governments are limited in their powers. And part of the function of the different ministries of government is to check and limit each other in more or less a traditional Madisonian sort of way. So you can actually assimilate a lot of standard American constitutional thought to the Hobbesian way of thinking if you theorize the sovereign of the United States as this strange kind of sleeping democratic sovereign. There's a good recent book defending this kind of view and describing its history by Richard Tuck, simply called The Sleeping Sovereign. It came out at Cambridge, I think, about 3 or 4 years ago. It's a very interesting book, and if you're interested in this issue, I would encourage you to take a look at it. So you can have limited government in Hobbes's view, you just can't have limited sovereignty, and I'll say more about that later on. Let me say one last thing about the structure of Hobbes's argument and the way in which he thinks about sovereignty as opposed to government and other aspects of politics. Keep in mind that Hobbes's contract defines only the legitimacy of a state and its sovereignty, but it doesn't guarantee that the state, and indeed its governments, are competent in securing the lives of its citizens. A government can have the right to decide for all of us how it preserves our lives and secures peace and order, but it doesn't mean that in having that right, it's going to do a particularly good job. Some states are going to do that job very effectively, and other states are going to do it relatively poorly. Hobbes's point is that the legitimacy of the state, the right of the state to assume that role, is independent of its competence. Now, that doesn't mean that Hobbes says nothing about the question of competence. To the contrary, he says a great deal about how responsible state sovereigns ought best to keep the peace and maintain order and preserve the lives of its citizens. And he says quite a number of interesting things. For example, he has in several passages, which I hope struck you as you read, he's willing to say, foreshadowing 21st century welfare state policies, he's willing to say, look, since poverty is often something that prompts members of society to resent their place in society and can sometimes stimulate crime and therefore can threaten other members of society, it's quite important for states to be prepared to alleviate poverty, to minimize the resentment and the crime and predation against the safety of others that it can often produce, right? So Hobbes is perfectly happy and indeed encourages the state to take concerted action, public charity, public welfare, to alleviate poverty as a way to promote peace and limit crime and deviance. As I mentioned in the last lecture, Hobbes is perfectly happy for the state to use the church and to officially endorse a national religion and require a uniform pattern of worship as a way to encourage attitudes of respect and reverence for authority and to encourage moral dispositions that motivate people to behave peaceably and amicably towards each other, right? I mean, the controversial feature of this view is that on Hobbes's account, the content of these forms of worship, the content of the theology that the state selects and tries to promote, is to be determined not by priests or theologians, because Hobbes distrusts those folks. The content of religion and the content of liturgy is to be determined by civil servants and public officials solely on the grounds of whether these particular religious rituals will in fact induce peaceable, amicable behavior among citizens. And this is a feature of Hobbes' view that gets him into a lot of trouble because, not surprisingly, this purely pragmatic view of religion is highly offensive to many Christians of his time who accuse him of being an atheist, above all because he endorses this manipulative view of religion and the church. And of course he also says, going back to some of what we talked about when I was talking about the state of nature, that ideally the civil law should include all of the provisions of the natural law. Everybody should be treated as an equal. There should be equity and impartiality in mutual dealings. As I mentioned a few lectures ago, there should be rules against overt expressions of contempt, what we would today call hate speech or hate crimes, right? Because again, those forms of speech act or those forms of hate crimes, they tend to foment conflict. And if a state is trying to tamp down conflict, it will seek to prohibit that kind of action, since that seems like an efficient way, to Hobbes anyway, to minimize social discord. So Hobbes says lots of things about how sovereigns can effectively and competently discharge their responsibility to keep the people safe. But again, the feature of his view that is distinctive is that Hobbesian citizens cannot demand of a state that it do any of these things as of right? Because Hobbes is concerned that as soon as you allow citizens to make that demand as potentially grounds for disobedience, then you're going down the road, which of course Locke is going to take, of potentially endorsing a right of resistance and a right of rebellion and a right of revolution. And Hobbes thinks that that road is a cul-de-sac that leads ultimately to violence, conflict, and war. And he wants to just barricade that option off completely. So Hobbes has various views on what a competent sovereign would do, but none of this is anything that Hobbesian citizens are in a position to demand as of right. And in taking this position, Hobbes is making, I want to suggest, an epoch-making move, because he's doing something that breaks strongly with the traditional ways of thinking about politics that had dominated Europe right through the Middle Ages, all the way back to Greek antiquity. Because prior to Hobbes, claims about the right to rule were typically connected strongly with claims about the goodness or virtue of rulers or states. Those of you who've read any Aristotle or Plato will know this, because Plato and Aristotle are constantly talking about who is qualified to do the job, right? They're constantly asking, how should we distribute political responsibility so that the right people with the right skills, the right virtues, the right dispositions of benevolence or whatever, so that they are in charge as opposed to incompetent morons, right? And Hobbes breaks with that view completely. It's not that he denies that we can make any headway with the question of what makes a ruler or a state effective or good at what they're supposed to be doing in keeping the peace. He accepts that you can have a meaningful discussion of this, and you can say that some states are doing a better job than others. It's just that he says that none of that grounds the authority to rule in the way states claim to rule. The grounding of the right to rule is independent of these kinds of claims. So Hobbes allows us to say, look, we can make a judgment about whether North Korea, Russia, Sweden, Germany, Britain, the United States are doing a better or worse job in keeping the peace and protecting the lives of their citizens, and no doubt some are doing a better job than others. But none of that matters for the question of whether these are legitimate sovereigns. From Hobbes's point of view, they're all equally legitimate sovereigns, and their right to rule is completely independent of our judgment of whether they're doing a good job or not, right? So keep that in mind. Okay, let me make a general observation about Hobbes's overall theory, and this will move us into a discussion of Hobbes and the implications of his theory for the value of individual liberty, which, as I mentioned earlier, many people have thought is imperiled by Hobbes's arguments. What I hope is coming across in these lectures is the following challenge that I think Hobbes poses to us. Hobbes is a really stimulating, provocative, and difficult thinker for us to reckon with, because he reaches conclusions that at least sometimes resonate with our own understandings of state power, but at other times strike us as tremendously dangerous and offensive and authoritarian, and that we're very strongly inclined to reject. But he reaches these often offensive and seemingly authoritarian conclusions on the basis of relatively slender assumptions that very few of you are likely to find it easy to reject, right? So his psychology is based on a basically materialist view about not only the world, but also human psychology. And again, that materialist view has become harder and harder to reject as modern science has developed, and we've found that the materialist hypothesis works pretty well as a way of explaining not only the outside world, but how the human body and how the human mind works. Hobbes is also a kind of relativist, right? I mean, he thinks that our judgments about good and bad are, in a strong sense, relative to our psychological appetites and aversions. And again, these days, liberal-minded, tolerant people very often endorse a kind of relativism. Well, you're coming from where you're coming from, I'm coming from where I'm coming from. Let's all just different strokes for different folks, right? Let's all just get along, right? But of course, Hobbes's argument is that relativism doesn't permit us to get along, right? Relativism causes conflict, and that's the problem that he thinks we have to sort of overcome. And of course, his arguments are completely secular. None of his arguments turn on the postulation of a God, nor do they turn on any particular interpretation of the meaning of the Gospels. And so again, he's arguing on the basis of assumptions that you may well find difficult to reject. So the question is, how does he reach these sometimes offensive and authoritarian conclusions, despite endorsing assumptions that are likely to strike us as fairly innocent? And I want to focus in the time that remains on the place where I think this issue is most acute, which, as I've already mentioned, is this question about what are the implications of Hobbes's position for the value of individual freedom. Because I think the first instinct most of us have is that Hobbes doesn't take individual freedom seriously enough. And what I want to do in the time that remains is talk a little bit about how Hobbes understands freedom and whether in the end his account carries conviction. And what I'm going to suggest is that Hobbes actually has some fairly powerful replies, although ultimately I will suggest that there's something that seems to be fundamentally missing from his account, and I'll end, if I get there, I'll end by explaining what I think that sort of missing link is. It's easy to understand why people have thought of Hobbes's political theory as threatening individual freedom. There are a number of reasons for this. Obviously, as we've been talking about already, Hobbes's position seems incompatible with the liberal idea of limiting state power, right? As we've seen, the Hobbesian sovereign is above the law. It's not constrained by any law. It is completely supreme and it is completely despotic. No legal rights constrain what it can do. Hobbes's citizens have no natural right to their freedom that they can press against the state. There's no right to resist, or only a really, really narrow one. And the right of civil disobedience and right to protest seem virtually non-existent on Hobbes's radar. Freedom of thought, freedom of speech, freedom of religion, and so forth receive no in-principle protection on Hobbes's account. And again, that's one reason, you wrap all of that up in a bow, that seems like a powerful reason to think that Hobbes doesn't take freedom seriously enough. A second point is that you'll remember that Hobbes denies that human beings have free will. And of course, that seems to threaten our ordinary notions of legal and moral responsibility or liability, right? I mean, if a tornado comes through and destroys my house, right, nobody thinks that it makes sense for me to kind of wave my fist at the tornado and say, how dare you, I'm going to send out a posse to arrest you and we're going to take you and we're going to blame you for destroying my house, right? We don't think that because we think of a tornado as just an event that happens. It's a natural caused event. The tornado had no choice. The tornado was simply caused by climactic forces to plow through my house. It's not to blame for destroying my house. If, on the other hand, you deliberately blew up my house, we would react very differently. We would say, why did you do that? We would blame you for wronging me. And that seems to presuppose that when we blame people for wrongdoing, we presume that they could have done otherwise, that they had some free choice to blow up my house or not blow up my house. But of course, Hobbes, in rejecting free will and in holding a completely deterministic view of human behavior, Hobbes seems to say that we're no different, essentially, from tornadoes. Our actions are just as causally determined as are the actions of asteroids, tornadoes, thunderstorms, earthquakes, and other non-personal things. And that raises the question of how does it make sense on Hobbes's view that we're able to hold each other accountable morally and legally for our conduct towards each other. It seems like Hobbes's refusal of a strong idea of free will undermines that very basic commitment. Third, and most notoriously, Hobbes, of course, defends slavery under certain conditions. And his argument here, which you're sadly also going to see Locke endorse, is the following. Look, if you have a war between two countries, which will be in effect in a state of nature with each other, because if they're warring with each other, there's no third-party authority, right? So all that's at stake is two different countries, each of which has their own independent right of nature to preserve themselves as they see fit. Suppose they go to war, and one country wins a decisive victory by invading and conquering the other state's territory, right? Under those conditions, Hobbes says, well, the conquerors have a right to kill those they conquer, because they're their enemies. They are free under the right of nature to judge them as their enemies, and if they wish, they can judge that they're a danger to their state and simply kill them. But of course, conquerors might instead offer the vanquished a slave contract. They might say, well, rather than kill you, here's an arrangement in which if you sign on the dotted line, you come back with me, or we put you on a ship and send you off to the colonies, in which you agree to serve as a slave, as a piece of property, to a master. And that master might be me, it might be someone in the colonies, it might be different people. But the point is that by offering slaves such a contract, or the conquered such a contract, the conquerors give the vanquished an opportunity to save their lives. but the condition of saving their lives is permanent indentured servitude, enslavement. And Hobbes says that the vanquished, since their alternative is that they might be killed by those who conquer them, they are compelled to sign such a contract by their own desire to survive. And that promise, Hobbes says, is still a valid, obligatory promise. And even more strikingly and problematically, Hobbes says, well, I know that these kinds of contracts are contracts or promises made under duress, because the conquerors are basically coercing them into signing a slave contract. But Hobbes goes out of his way to argue that promises made under duress are still valid. As he puts it, I think promises extorted by fear are still valid promises. And that seems like a really weird view, and a view that seems very hard to reconcile with our ordinary intuition that freedom is a very good thing, and that slavery is fundamentally wrong under any conditions. So these are three powerful reasons to think that Hobbes's understanding of freedom is profoundly inadequate, and that he needs to shore up his view in some way. And I'm going to say a few things about this, partly to defend Hobbes a little bit, but in the end, as you'll see, I think that this criticism of Hobbes does in fact go through on at least some important points. But it takes some effort to see exactly where he goes wrong, because a lot of what he says about freedom actually isn't so bad on reflection. Hobbes himself discusses freedom and political freedom, and he has a very distinctive view of how we should think about freedom. And I want to just explain how Hobbes himself understands freedom. And you'll have seen this in some of the passages that by now you will, I hope, have read. He interprets freedom in a negative rather than a positive sense. And when I use this language of negative liberty and positive liberty, I'm drawing on a famous distinction that is due to a 20th century political philosopher and intellectual historian, Isaiah Berlin, who lived from 1909 to 1997. And in a famous essay, Two Concepts of Liberty, Isaiah Berlin draws a useful typology between two different kinds of political freedom, one of which he calls negative liberty and the other which he calls positive liberty. And as we'll see, Hobbes sides with a negative account of liberty. So let me just explain the distinction first of all. On a negative account of liberty, Berlin says, political freedom is a function of the absence of something. And what is absent when we're free on this negative liberty account are interferences to possible action, obstacles, impediments, things that prevent us from acting in particular ways, things that close off options. So on a negative account of freedom, unfreedom consists fundamentally in constraints, impediments, forms of confinement, options closed off, and so on. If I'm incarcerated in a prison cell, my negative liberty is greatly curtailed, right? Because the walls of the cell and the locked door prevent me from leaving, right? My liberty of movement is drastically curtailed. There's not a whole lot of options available to me. My actions are drastically constrained by these external obstacles that are confining me. And that's one way Berlin thinks that we sometimes think about political freedom. We sometimes think of it in that negative way as a function of the absence of these forms of confinement, right? If the door was unlocked, and I'm in a prison cell, then suddenly I become freer than I was before, because now I have one important new option. Namely, I can walk out of the door if I want, and go out into life and pursue many other possible options, right? So that's negative liberty. Positive liberty, for Berlin, involves the presence of something. One is positively free to the extent that one enjoys control or mastery over one's own actions and choices, the extent to which one is a self-determining being, the extent to which one is autonomous. One decides what it is that one wants, and one is in a position to act on one's own conception of how to live, right? So positive liberty requires that a certain kind of self-mastery, a certain kind of control, a certain kind of government over ourselves is available to us. So on that positive liberty account, unfreedom consists in things like coercion, or duress, or slavery, or manipulation, or control by alien forces, right? When I'm a slave, for example, I'm not in charge of my own actions, right? My master tells me what to do, and I can formulate a plan of life for myself, but I'm not in a position formally to actually execute that plan because I'm not in control of my own actions. My master owns my actions. Or think of an act of coercion like a mugging, right? If you're accosted on the street by a mugger and the mugger says, your money or your life, right? In effect, what the mugger does is to commandeer your choices by threatening you with a knife in the stomach or a bullet through the head or whatever it might happen to be. The mugger is basically invading your will and determining how you choose on this occasion by introducing a new and devastating threat. In handing over your wallet, right, you are in a way doing what you want to do, right, in that moment, right? But your choice to hand over your wallet is in no sense your will. It's in no sense your choice. Rather, the mugger, the coercer here, is basically dictating your options. And that's incompatible with the idea of positive liberty, of being in control of one's own actions and one's choices. And that, of course, is one of the reasons why we dislike being coerced, because we feel that we're no longer in control. Notice, this is a small point, but I just want to highlight it because lots of people make this mistake. This distinction between negative and positive liberty is not the same as the distinction between positive and negative rights. That distinction between positive and negative rights is the distinction between rights not to be killed and rights not to be stolen from versus there's a negative rights versus positive rights, which imply a right that somebody else provide you with some specific benefit, right? Now that distinction may be related in various ways to the negative-positive liberty distinction that Berlin introduced, but it's a different contrast. It's also not good, although you'll see this in some literature, it's not good to contrast negative and positive liberty just in terms of freedom from and freedom to, because I think that the language of freedom from and freedom to, both sides of that equation really belong under negative liberty, right? Because if I'm imprisoned in my cell, right, I am not free from impediments to action, and I am therefore not free to leave the cell insofar as the door is locked, right? So when people say, well, negative liberty is freedom from and positive liberty is freedom to, they really misreport the distinction that Berlin intended, which is a distinction between liberty as the absence of interference versus liberty as the presence of self-determination. Okay. Now, Hobbes has a concept of freedom which he quite explicitly defends in Leviathan, and you'll remember the passages where he does so. And it's clear that he just doesn't really recognize or use the positive conception of freedom. His understanding of freedom or liberty is a purely negative one. Here from chapter 14 is his basic definition of liberty. By liberty is understood, according to the proper signification of the word, the absence of external impediments, which impediments may oft take away part of a man's power to do what he would, but cannot hinder him from using the power left him according as his judgment and as reason shall dictate to him. Hobbes understands political liberty in this negative way, I think, in order to come up with a conception of political freedom that is completely distinct from the idea of a free will, right? Because we know that he rejects the idea of a free will, so he can't define freedom, political freedom, in terms of, as it were, rising above causation and choosing actions in a kind of uncaused way, right? And he's attracted to the concept of negative freedom because he notices, and this is, where one of the places where Hobbes is characteristically really clever, right? He notices that inanimate objects can also be said to be free or unfree in the negative sense. And he uses the example of bodies of water. Right? I mean, clearly bodies of water don't have a will, right? They don't choose. They just sit there. But liquid like water can be confined or not confined in different ways, right? So you could channel water so that it all goes into a tank. And once it's in the tank, the walls of the tank keep the water in there. And as long as those walls are intact and don't rust away, the water is, to put it in Hobbes' terms, not at liberty to leave the tank, because there's an impediment. There's something that prevents it from moving out of the tank. Alternatively, if the tank does start to rust away and leaks start appearing, well, now the water is free to leave the tank, right? But in making these judgments about whether the water is, as it were, free or not free to leave the tank, we're clearly not postulating that the water has any will. We're just talking about an inanimate object here. But even inanimate objects can be said to be less or more free according as they are more or less confined. As he says in chapter 21, of the water whilst it is kept in by banks or vessels that otherwise would spread itself into a larger space, it is not at liberty to move in such manner as without those external impediments it would. Okay, so Hobbes understands freedom in a rigidly negative way, and he thinks of political freedom in just that way. So he says, look, I know you think my view is authoritarian and I don't care about liberty, but there's a sense in which citizens do enjoy and can enjoy genuine political freedom under my authoritarian Leviathan, because they can be said to enjoy political freedom insofar as they operate within, as Hobbes puts it, the silence of the law. If the sovereign is not forcibly preventing or legally prohibiting citizens from doing X, then it follows they are in effect free to X, politically speaking. There is no political obstacle put in their way by the state that prevents them from performing the relevant actions. So, on Hobbes's view, citizens can enjoy real freedom, even under a Leviathan state, anytime there's some area of life that is not regulated by law. If there are no laws against, engaging in certain activities, if the state doesn't place constraints in the path of citizens who want to go play soccer on a Saturday afternoon, that's not regulated by the law. The law doesn't prohibit it. The state isn't going to intervene to prevent you. And so in that sense, you are free to go and enjoy recreation on a Saturday afternoon, right? You're negatively free because the state isn't imposing any obstacle, isn't constraining you from doing that. That would be a kind of implicit case. But with regard to constitutional law, sometimes the sovereign will can make it very explicit, because the Constitution might say, as in fact the United States Constitution does say, that there could be certain arenas, certain areas of legislation in which it is accepted that the legislature, Congress, say, or Parliament, is not permitted to pass laws, right? So, all of the Bill of Rights stipulations in the American Constitution, many of which start with, prefixes like Congress shall make no law, right? They're effectively imposing on legislatures an obligation to not impede citizens' freedom in certain areas, like freedom of religion, or freedom of speech, or freedom of the press, right? And so Hobbes is able, under this negative account of liberty, to give a pretty good analysis, in some ways, of what it means for citizens to enjoy real freedom, even under his Leviathan state. But that may not be enough to convince you that he's got a good understanding of political freedom. And there are at least three objections that are likely to occur to you here. One objection is that, okay, so this is a clever move to understand freedom completely negatively, but it's still too thin to capture what we would ordinarily mean by political freedom, which would include a heavy dose of what Berlin called positive liberty, namely the recognition of rights to personal autonomy or personal self-determination. And one might object to Hobbes, well, he doesn't really take that seriously, right? A second and perhaps closely related objection is associated with the tradition of civic republicanism and was in fact directed at Hobbes during his own day, especially by an English civic republican, James Harrington. When we talk about civic republicanism here, we're just talking about political theorists who are in the tradition of political thinking that comes out of the Roman Republic and that was very popular in the Renaissance and in the early modern period. And on this second civic republican neo-Roman objection, Hobbes' state doesn't really guarantee individuals real political freedom, because as long as the state retains, as Hobbes says it does, of course, because the state can choose at will to confer or withdraw various kinds of negative freedoms on its citizens, as long as the state retains the right at will to withdraw any negative freedoms that citizens currently enjoy, then citizens are not really free. They're in fact enslaved. And people today often put this point in terms of a contrast between states like China and the United States, right? So in the United States, there are various kinds of checks and balances, right? Government agencies can't just take certain freedoms away. Citizens have recourse to ways of complaining, right? They can sue the government for taking away their freedom of speech. And that is an important protection that civic Republican thinkers have insisted on. And today people look at a country like China and they say, well, none of those checks are in place there, right? If the Chinese Communist Party decides to take the rights of a certain group of citizens away, then those citizens have no recourse, right? And these civic Republican objectors basically say, well, look, Hobbes sees no difference between China and the US, and in failing to see that relevant difference, Hobbes is just proving that he doesn't really understand freedom and its significance. A third objection would be, while Hobbes permits and could encourage the state to enforce freedom of religion, thought, and speech, his view doesn't, of course, require it to do so. If the sovereign judges that we're going to have one religion and we're going to impose it on everybody because that's the best way to keep the peace, or if restrictions on certain kinds of hate speech are appropriate in the judgment of the sovereign, then the state enjoys an unlimited right to pass legislation restricting those freedoms. And again, that may seem to give the state way too much power and control over citizens' freedom. Does Hobbes ignore positive liberty? It's true that he doesn't have the concept of freedom as self-authorship or self-direction or as autonomy and so forth, but I think there are a couple of things that one might say to defend Hobbes here. One thing is, it doesn't follow that even though he doesn't have a concept of positive liberty, it doesn't mean that what we mean by autonomy would receive no protection in a Hobbesian state. I think it's particularly important to notice here that Hobbes explicitly wants to protect freedom of contract. And he regards the protection of freedom of contract as an essential condition for the creation of what we would today call an economy and civil society. And Hobbes makes it clear that freedom of contract implies that price determination is something that should be worked out freely by contractors as they higgle and barter in something like a free market economy. Hobbes is also no big fan. He's not a fan of price controls by the state, and he's also no big fan of monopolies or oligopoly. He thinks those are generally a threat. He thinks, in principle, you can regulate industry in the workplace. So if you think that the sweatshop is a threat to individual autonomy because it's basically a form of modern-day slavery, and it fails to protect people's lives, then the Hobbesian state is free to regulate and indeed perhaps even criminalize that kind of exploitation. I've already talked about the provision of welfare services, of unemployment benefits, and the provision of guaranteed public education. You might think that, education is important for promoting individual autonomy. It enables people to deliberate about what they really want. And all of those things are protected by Hobbes's state, or at least potentially made available to citizens. Hobbes makes it clear that rape, assault, muggings, coercion, all of this sort of thing by private individuals is verboten, and the state passes laws to protect people against that sort of thing. So you might think that these are ways in which something like autonomy, even if Hobbes doesn't call it liberty, they do receive some protection in Hobbes' story. I think it's also important to notice that, in a way, Hobbes' overall political theory is a kind of positive liberty theory, because he thinks of societies as rationally self-determining. After all, on Hobbes' account, we author the state. We create the state. It represents our will. We choose to determine ourselves by entrusting our security and self-preservation to our sovereign. And there's a sense in which that implies a certain commitment to national self-determination or collective self-determination. And that may in fact, imply that buried in his theory is an implicit, admittedly unnamed, but an implicit commitment to positive liberty. Okay, I've reached 50 minutes, so I have to stop here, and so I will have to hang over some of the remaining points from this lecture into the first lecture on Locke. I don't think that's a tragedy, because in many ways this discussion of liberty will help us to move seamlessly into Locke, because of course Locke is arguing for an account of political sovereignty and political society that is, at least officially, much more attentive to the importance of liberty. So I'll stop here now and continue this discussion of Hobbes on freedom in the first part of the next lecture, which of course will be a lecture eventually on Locke. All right, thanks for listening. Talk to you soon.